On April 8th, the Supreme Court declared Tamil Nadu Governor R.N. Ravi's prolonged refusal to give his assent to 10 bills as illegal and erroneous in law. In landmark verdict, Justice J.B. Pardiwala and R. Mahadevan underscored the importance of cooperative federalism amid amid growing concern over the increasing politicization of governor's office in opposition-ruled states. Then we should understand the process of granting assent by the governor. Article 200 of the Constitution delineates the power conferred upon a governor when a bill has been passed by the state legislature. So, Article 200 is very important article to be remembered for all the examination, not only for the UPSC but for every examination, and it should be also understood by each and every citizen of India. The only exception is money bills, which are deemed to have automatically received assent. So, the money bill, when money bill is sent to the governor for the assent, then it is automatically received assent. Why? Because money bills are put before the house by the consent of the governor. In all other cases, once a bill has been passed by both houses of the legislature, if they are dual houses, then the governor can exercise one of the four options. First option is grant assent. Second option is withhold assent. Third option is return the bill to the assembly for the reconsiderations. And fourth option is reserve it for the president's considerations. However, only those bills that undermine the High Court's powers to the extent of endangering its constitutionally mandated role can be reserved for the presidential considerations. So, only one case the bill can be reserved for sending to the president, that is, if the bill undermine the powers of the High Court. Otherwise, this bill should not be reserved for sending to the president. The first proviso to the Article 200 stipulates that if the governor decides to withhold assent, the bill must be returned to the assembly as soon as possible, accompanied by a request to reconsider the proposed legislation or suggest amendments. However, if the assembly upon such reconsiderations passes the bill with or without amendments, the governor is constitutionally bound to grant assent. So, if any bill is passed once again by the legislative houses, then governor must give assent to the bill. Can the governor exercise a pocket veto? This question has been arisen again and again. So, this question was answered by Supreme Court in this judgment. The ongoing impasses between the governors and opposition-ruled state governments primarily hinges on the interpretation of this proviso. While it mandates prompt action, it stops short of prescribing a definitive timeline. This constitutional silence has often been exploited by governor to indefinitely delay action on a bill without formally returning it, a tactic colloquially known as the pocket veto. However, the judges pointed out that the use of the term shall in the substantive portion of the Article 200 shall, the substantive portion of the Article 200, when read in conjunction with the phrase as soon as possible in its proviso, precludes the possibility of any such pocket veto. It means that Supreme Court had declared pocket veto by governor unconstitutional. So the Justice Pardiwala, who authored the judgment, clarified that the governor's option to withhold assent cannot be equated with an unqualified power to reject or veto legislation duly enacted by the state legislature. He cautioned that such an interpretation would undermine the very foundation of a representative democracy. It means that in this judgment, the importance of representative democracy has been focused when about president's considerations. Further limiting the discretionary powers of the governor, the court ruled that the bill cannot be reserved for the president's consideration once it has been returned to the state legislature, reconsidered and resubmitted for assent. What does it mean? It means that if the governor returned the bill for the reconsideration and if that bill has been resent once again to the governor, then that bill cannot be sent to the president. Why? Because but there is only one exception in this case. If the bill in its second iteration is materially different from the original versions, the judgment also clarified that such reservation cannot be based on a personal dissatisfaction or political expediency. And it is only permissible in instances where there is a grave threat to the democratic principles. Notably, the judges have set a 3 month deadline for the president to decide whether to assent to bills referred by the governor. It means that for the first time, the Supreme Court has set a deadline even for the president. The clock will begin ticking from the day the reference is received. Any delay beyond this period must be accompanied by justifiable reasons and communicated to the concerned state. It means that it has given importance to the legislatures, that is the voice of the people. A recommendation has also been made to the President to seek the Supreme Court's advice on such bills in line with the procedure outlined in the Article 143 of the Constitution as a measure of prudence. The judges point out that this course of action is important given the lack of mechanism at the state level for the governor to refer bills to Constitutional Court for their opinion. As governor has no such power to seek what are the timelines prescribed. The court has imposed similar timelines on the governor to prevent any obstructions of the state legislative process. It clarified that when the governors acting on the cabinet's advice opt to withhold, assent or reserve a bill for the president's consideration, such action must be taken forthwith and no later than 1 month. It means that within 1 month, that bill has to be sent to the governor. If the governor withholds assent contrary to the ministerial advice, the bill must be returned within the 3 months, accompanied by the message detailing the rationale for the decision. Similarly, if the governor reserves a bill for the president against the cabinet's recommendation, this must also be done within 3 months. Finally, if the bill is repassed by the state legislature after reconsiderations, the governor is required to grant assent within 1 month. However, the ruling noted that any departure from these timelines may be condoned if there are reasonable grounds. It means that ground has been left for the governor. Is judicial review permissible? The judges emphasized that any exercise of the gubernatorial discretion must be amenable to the judicial review to prevent any disregard for the will of the people as expressed through their elected representatives. Invoking its inherent power under Article 142 of the Constitution, the court deemed the 10 pending bills to have received assent. Justice. It means that the history has been created by the Supreme Court. For the first time, the bill has been passed without receiving assent by the governor, but we can say that the governor has given assent as he was not able to take the decision. The Justice Pardiwala reasoned that the exercise of such extraordinary powers was warranted given the governor's scant respect for prior rulings. He was particularly critical of the governor's decision to return the bills without providing reasons, in clear violation of Supreme Court's binding directives in the state of Punjab versus the Principal Secretary to the Governor of Punjab. What are the potential implications? PDT Acharya, former Secretary General of the Lok Sabha, told the Hindu that the ruling upholds the principle of federalism and provides opposition ruled state governments a clear constitutional remedy against inordinate delays by the governors in granting assent to the bills passed by the legislatures. Thus, The Supreme Court has been running in the discretionary powers of the governors for some time now. However, what set this judgment apart is its articulation of definitive timelines for both the governor and the president, ensuring that the enactment of the crucial legislation is not indefinitely stalled. He said, Senior Advocate Shadan Farsad noted that the top court has rarely invoked its inherent powers to create a legal fiction of deemed assents by recognizing automatic assent in cases where the governor fails to adhere to the prescribed timelines. The court has instituted a crucial safeguard against abuse of the office by the governor. He said he added that the ruling would pave the way for the similar judicial interventions in cases where the Union government delays acting on the collegium recommendations. Extending such powers to judicial appointments would help prevent an executive veto over the collegium's decision, he told the Hindu.